Hello, everyone. My name is Pulat Yunusov. I'm a commercial litigator here in Toronto, and this is a very special episode of the Yunusov Question. I have one of my previous guests back. Her name is Ewa Krajewska. She's partner with Henein Hutchison Robitaille LLP here in Toronto. And the reason we met for this very special episode is because something happened at the federal court a few days ago. And we will ask Ewa all about it. She acted for Canadian Civil Liberties Association in a very important case where the federal court considered the legality of the Emergencies Act proclamation of the declaration of a national emergency in Canada about 2 years ago. Hello, Ewa.
Hi, Pulat. Nice to see you.
Very nice to see you. Always great to see you. And is my introduction more or less on point?
It's perfect.
Okay, thank you. Thank you. It's really important when praise like you comes from, praise like that comes from a person like you. Thank you so much. So first of all, tell me what happened. Tell me, summarize the decision. What's going on here? Why is everybody so excited about it?
So the CCLA launched this challenge of the government's decision to invoke the Emergencies Act within days of it being invoked. So it was invoked on February 14th, and we brought the challenge. We filed that challenge that week because the CCLA believed that the government was probably not justified in invoking the Emergencies Act. And this is a significant decision because this was the first time that a government in Canada has ever invoked this act. And it was the first time that a court has ever ruled on the legality of invoking the act and therefore provided guidance for future governments as to when it would be justified to invoke this extraordinary piece of legislation.
Do you think this was the most important case of your career?
I don't know.
So far. The Emergencies Act, first time ever invoked, national significance, national emergency. The act was written for wartime, basically crisis threatening Canada's existence. And you are the lawyer who got to shape the case law, the interpretation of this act by the courts.
Okay, well, when you say it that way, then maybe it is, but I feel like, like your cases are like your children. It's like hard to choose which one are best.
So are you on a call with Canadian Civil Liberties Association? You told me that you brought this application days after they invoked the emergency. So take me through the events of how you were retained, what happened there, why the decision was made, and how.
Okay, so, going back, like during COVID, I was pretty active in giving advice and educating myself on various emergency pieces of legislation. I had given advice and tweeted on social media all about, especially in Ontario, the invocation of the Emergencies Act in Ontario to respond to the COVID pandemic. I was really well versed on emergencies issues as a result of COVID. And when the government invoked the Emergencies Act, I did a long Twitter thread explaining kind of the thresholds around invoking it. And at the same time, I've also had a really good relationship with the CCLA for many years. I've acted for the CCLA on various cases, and including in front of the Supreme Court of Canada. I knew the lawyers at the CCLA. And so within days, they reached out to me and said, Ewa, we want to challenge this. We want you to be our lawyer. Will you do it? And then, then I go down to Marie's office and I say, can I do this? And she says, is this an important legal question? And I say, yes. And then we go, yes, we're doing it. So that I was felt very, very privileged to have the CCLA have confidence in me and in Brendan and in Matt Gourlay, who all worked on this together. We had to file the notice of application really quickly because we had no idea for how long the Emergencies Act would remain invoked for, how long the period of emergency would stay. And so we wanted to have a court review it immediately. I mean, that was the plan, get into court immediately. That's not exactly how it turned out. It took a while for this to get before the court, but that was the idea.
Right. And thank you for the Marie Henein reference. I always live to hear Marie Henein references. She was a guest of the show. Everybody should watch that episode. Brief plug for the Marie Henein episode. Now, you said this is the first invocation of the Emergencies Act, the first time the court considered the Emergencies Act, but the Emergencies Act had a predecessor, correct?
It had a predecessor in the form of the War Measures Act, correct?
And that act was invoked by Mr. Trudeau, not this one, the father, the previous one. And can you give us a little bit of a history? So why is the Emergencies Act that we have today the way it is? Does it have anything to do with the War Measures Act and how it was invoked?
Yeah, so the War Measures Act was invoked in response to the crisis in Quebec, in response to this FLQ movement, where cabinet ministers in Quebec were kidnapped, and I believe one of them was murdered eventually by this group. And there was controversy later about the invocation of the War Measures Act in response to that crisis. And so in the 1980s, there was a movement to modernize the Emergencies Act. And that was significant because there was a recognition that states, countries in the modern era face crises and emergencies that are not just in the form of war, right? The War Measures Act is something that was very much more responsive to an older world order. And so our modern Emergencies Act has different criteria for different emergencies. There is a criteria for war, there's a criteria for a natural disaster, and there's a criteria for a public order emergency. So that's what we were dealing with here. It was invoking the Emergencies Act in response to a public order emergency.
So explain something to me. The COVID pandemic that lasted a gazillion years and shut down the whole country, and they put everybody under home arrest basically initially for a few months and so on and so forth. They didn't need to invoke the Emergencies Act to do that. That was, I think, something close to a national emergency when we had the COVID pandemic in 2020, and the rules, the lockdown were quite harsh. Much harsher than freezing a few bank accounts and arresting a few truckers. They froze the entire country. So, but they didn't need to invoke the Emergencies Act to accomplish that. So, what happened? What tools did they use? Why didn't they just use the same tools in this case?
So they used similar tools, but the operative word is who is they. Okay. So what happened is, during the COVID pandemic, most of the rules and regulations that were implemented pursuant to public health measures were implemented by provincial governments. So provincial governments relied on both their Emergencies Act. So each province has an Emergency Act, and they relied on those. And each province also has public health acts, and they relied on those. And the federal government during the COVID pandemic had regular calls and regular contact with the provinces and discussed with the provinces whether the federal government should also be invoking its Emergencies Act. And the federal government decided that it did not have to, because the existing laws and of the provinces were sufficient to deal with the COVID pandemic. Obviously, the federal government also implemented its own measures. Most of those were related to immigration, citizenship, movement across borders. All the border issues were implemented by the federal government, but they did that through their existing legislation. Similarly, any federal undertakings like aeronautics, planes, trains, maritime stuff, the government also did through its existing legislation. So all of the emergency measures that were implemented during COVID were just done through other pieces of legislation, and we didn't need to resort to the Federal Emergencies Act.
And wasn't one of the arguments of the federal government in your case that provinces gave up, or provinces couldn't do it, or provinces didn't have the ability to do it, so they had to intervene? And this reminds me of the G20 protests in Toronto quite a few years, where, you know what, a similar situation arose, where a large number of people staged protests while foreign dignitaries were in town. And we actually did have blockades, but the blockades were by the police because they wanted to protect the dignitaries. And the police response was immediate, very harsh, and the protests were ended by force right away. So what changed since then? Do you have any idea, any thoughts about why the same thing didn't happen in Ottawa without using the emergency? They did not invoke the Emergencies Act, neither provincial nor federal, during the G20 protests, if I'm not mistaken. They simply used police authority. In fact, the government didn't do anything. The police exercised its authority independent of the government.
Right.
But, you know, I'm just trying to see what's going on. Why was this situation so unique in Ottawa 2 years ago?
Okay, so this is like a little bit of legal stuff and a little bit of factual stuff. Let's step back for a minute. So in order to invoke the Emergencies Act, the federal government has to be satisfied that the existing laws of Canada, so the laws that exist on the books or in practice, cannot address the crisis. Okay. And what the court found was that, in fact, the existing laws of Canada could address the crisis. For example, the federal government said, look, we discovered weapons in Coutts. It was super dangerous. But the court says, yes, but you discovered the weapons in Coutts by exercising a warrant granted by a court pursuant to the criminal code, right? You are relying on existing laws. And you're right that G20, now this is going back when I actually started practicing, I was actually kind of on standby that weekend, and the CCLA played a big role actually in the G20 and the aftermath of the G20 in terms of holding the police to account for some of the stuff that the police did, including kettling protesters at Yonge and Spadina, which I think was a very scary thing that happened. But as you say, there was a perimeter that was created around the G20 summit at the Intercontinental Hotel. Protesters were not allowed to enter it. Instead, protesters went down Yonge Street and based King and Bay. There were cars being burned at King and Bay. There were shopping centers, the Ian Center along Yonge Street, that were just, Molotov cocktails were thrown into them. Like it was a disaster.
Much more violence, by the way, back then than in Ottawa 2 years ago. Would you agree?
I don't know. I wasn't in Ottawa. I was in Toronto, so I don't know. But I think the people in Ottawa felt that the honking that happened in Ottawa was violent to them. So I will say that. So what happens here, I think, I participated also for the CCLA at the Rouleau Commission. And a lot of this factual background really came out in the Rouleau Commission, a lot more than in the court, right? The court was not dealing with all this factual background. But at the Rouleau Commission, what became clear is that at least in Ontario and in Ottawa, once the Windsor Bridge was blocked in Ontario, the Ontario police force and the Ontario government became very concerned about these protests. The OPP helped the Windsor police clear the Windsor Bridge. And once that bridge was cleared, there was enough police power to help clear the protests in Ottawa. And I think the problem in Ottawa is that there was not enough of a police force to deal with the protest. And if, going back to the G20, when the G20 was happening in Toronto, you not only had the Toronto Police Force, you also had the OPP, you had the RCMP, you had all of these police forces that were here to supposedly manage the protests. And I think the OPS just did not have the police resources to deal with it. And there was, especially once the trucks actually came in and were unable to move, and the police felt like they were unable to move the trucks.
I see. Well, before we dig into the actual case and into the actual decision, I still want to talk a little bit about the days 2 years ago. So you got the call, and you wanted to, I assume, have an emergency hearing and get an emergency injunction to block or to set aside the proclamation. This was your strategy. Why didn't that happen?
So it didn't happen for, I think, a few reasons. First, the invocation was revoked pretty quickly, like within 10 days of being implemented. So that's the first thing that happened. The second thing that happened was after the invocation was revoked, there became kind of a question of how is this going to move forward and how is this going to be scheduled? And originally we were canvassing dates to have the judicial review scheduled in June of 2022. And the federal government and the lawyers for the federal government were saying, well, the first argument that we want to make and the first motion that we want to bring is that all of this is moot. Mm-hmm. And we want to schedule that first. And we resisted that. And to Justice Mosley's credit and to the credit of the federal court, he made the decision that the issue of mootness would only be decided at the actual hearing. So he was not going to schedule a preliminary motion on mootness. So, okay, so we're going to go for June. And then what also becomes clear is this is very unique to judicial reviews of government action, is when you bring a judicial review of any other tribunal decision, any decision of a government actor, the government actor has to produce a record of proceedings. They have to produce a copy of all the documents that the decision maker considered in making their decision. And here we have a problem that it's cabinet. And we have a thing called cabinet confidences. And so the government, we want production of the record that was before cabinet. And the government says we're not producing this because it's covered by cabinet confidences. We have a motion on that. We have a motion on that in the summer of 2022. And in the meantime, the Public Order Emergencies Commission is taking place. And to its credit, the federal government decides that as part of that commission process, they partially waive cabinet confidences. So they waive what they call all the inputs that cabinet received in making its decision. They maintain cabinet confidence over all the deliberations of cabinet, but they decide to produce everything else. And so thankful, great, and this is maybe the government has set a very good precedent for the future, that future governments will also do that, which is they will waive cabinet confidence with respect to inputs. And so as part of the commission process, we start to get all of these documents from cabinet, including text messages between ministers. We get lots and lots of documents. And then we keep pushing for a hearing. The commission is happening. We keep pushing for a hearing. The hearing doesn't take place until April of 2023.
Why?
So one thing that happens is during the commission, we get all of these documents, important, critical documents from the government. Some of these documents, Justice Mosley actually appends to his decision. including a memorandum from the clerk of the Privy Council summarizing all the information that was before Cabinet in making the decision. And we say to the government, all of this information that you have produced before the Commission, that was before Cabinet, should also be before the court. It should form part of the record of proceedings. And so we bring a motion to admit that evidence so that Justice Mosley has the benefit of that evidence. The federal government resists that motion. It's a motion in writing. We have it heard over, we write it and argue it in writing over the Christmas holidays last year. But we're successful. We're successful in getting those documents before the court. And then the government says, well, if you have those documents before the court, here are these other documents that we also want to file. They get to file more documents. And then we finally manage to schedule hearing dates in April of 2023. So like a lot of pieces of litigation, Poulat, there were just a lot of interlocutory motions. There were interlocutory issues, but they were really, really important issues. They were important issues around Cabinet confidences. There were important issues around what should form part of the record. So even though everyone had the intention to have this heard quickly, I like most pieces of litigation, it takes more time, although, you know, it's not a bad amount of time, all things considered, right?
The government is here to protect the public interest. I think everybody will agree with that. It is in the public interest to ensure accountability when government exercises force against Canadian citizens, especially in the non-criminal context. In the criminal context, we have the standard criminal process, which is really old and tried and true. This was a non-criminal process, and partly this is why a lot of the issues arose. So the government resisted accountability on three fronts. First, it resisted the accountability by arguing that the issue was moot. So it opposed testing what happened because they say there are no practical consequences of this decision anymore. We withdrew the proclamation of the emergency. So they resisted, number one, on the ground that the issue was moot. Number two, they resisted accountability by claiming that their record is secret and that it's secret and privileged. And number three, they resisted accountability by blocking the evidence before the Commission of Inquiry, which was a completely separate process from entering this judicial review application and from being in front of the judicial review judge. So they resisted accountability on these three fronts. And you're telling me that we have to give them credit, at least on one of these fronts, where they partially waived privilege or confidentiality over the record of their decision, of the deliberations. How hard did they resist on the other two fronts, on the mootness? How hard did they resist on the admissibility of the evidence before the Commission of Inquiry? How hard did they resist on those two fronts, and why did they resist at all? And did you, as the applicant, raise the fact that as a public interest defender, the government is not supposed to resist accountability in such a way, that this is purely a technical ground that we see in commercial litigation between private parties and shouldn't really see when government action is reviewed by the courts?
Yeah, Paul, when you ask me that question, it makes me reflect on how the government acted very differently in the Commission than it did before the court. So in the Commission, we saw an enormous amount of cooperation by the government in producing Cabinet confidences and in producing its ministers and the Prime Minister to be cross-examined in front of the Commission, right? Ontario did not allow their ministers to be cross-examined. So you had an enormous amount of cooperation from the government at the Commission for the purpose of accountability and transparency. And yet the litigation strategy of the government before the court on the judicial review was to set up these roadblocks, including on mootness, cabinet confidences, and then the record. Now, how hard did they resist? I mean, they made the arguments, they didn't call it in, they made the arguments. I'm not sure the mootness arguments were very good arguments, but those were their instructions. That's what their counsel argued. But obviously, even though the proclamation was moot, there was absolutely a bit higher interest in having this decision heard. And part of their mootness argument was, well, but the commission's dealing with this. Justice Rouleau's dealing with this. We don't need a court to deal with this. You're not relevant, court. And our submission, which was accepted by the court, was that the commission of inquiry and the court play different roles in accountability, different roles in transparency, and they're both essential for civil liberties and the rule of law to be respected. And so it is, I don't know, like maybe one day we will find out why the government took these very different approaches to these two different processes, but they were very cooperative. I mean, they waived cabinet confidences. Poulat, this rarely happens. It never happens. It never happens. Okay, they did that. It's good, and it's a good precedent for the future. And yet they were on the litigation front, they were very resistant.
As an expert on commissions of inquiry, and at the same time as an expert litigator, tell us if the difference between the commissions and the courts is in how binding the decisions are. Is it fair to say that the commission's findings are not really adjudication, they're not really binding on the government in the future, but the court's decision will set the precedent, will bind future invocations of emergency?
I think strictly speaking, you're right. I think both of them carry an enormous amount of weight in the public and in public opinion, but they fundamentally fulfill slightly different mandates. I mean, Justice Rouleau's mandate was much, much broader, much broader. He not only looked at the invocation of the emergency, but he was also looking at what led to the Freedom Convoy. Why were people so upset that they came out and protested? What's the role of social media? His role is also to provide suggestions on how to improve the legislation. It's a huge fact-finding role. It's a huge investigative role. It's much more of an inquisitorial process. And the role of the court is different. The role of the court was much narrower. It was really looking at the legality of the decision, strictly speaking. And it was looking at whether the test for the invocation of the act was met and how that test should be interpreted by future governments.
So something is really interesting to me. And I wonder if we can draw broader conclusions about the state of policing in Canada today, and about the state of invoking government or making decisions in general. So this is what I'm talking about. The Emergencies Act was invoked on February 14th, 2022. Governing Council declared a public order emergency under the Emergencies Act. So before that, the police did almost nothing. The border was blockaded. The trucker convoy took over downtown Ottawa. There was very little or no police action. Within a day of this simple stroke of pen, it's like the dominoes started falling. Almost immediately, on the following day, the border blockade is cleared. The police are starting to move in on the Ottawa protesters. Do you have the impression that the police simply received legal advice, that they were putting themselves at risk of liability for moving on the assembly, on the protests, and they were waiting for legal cover to do that? And do you think this is in general becoming now the issue with policing, where there is the old style, old school, clear-cut policing, criminal offenses, arrest the murderers, the thieves and so on. But then when there is a political protest that is maybe crossing the line of public order, they don't do anything. I'm talking about the recent protests in Toronto. I'm talking about many, many protests during the pandemic. I'm talking about protests in the US during the pandemic. And now the Ottawa convoy, the dominoes started falling immediately after the stroke of the pen. Were they waiting for the stroke of the pen? Were they waiting for the legal cover? What do you think?
So I'm not sure. I don't know. I don't really know. The Windsor Bridge was cleared before the invocation of the Emergencies Act. So the OPP and the Ontario government were not waiting for the invocation by the federal government of the Emergencies Act. I think the government of Ontario, once the Windsor Bridge was blocked, the government of Ontario was deeply concerned about this, and the OPP started to make a plan very quickly to clear that bridge. I think in Ottawa, we know from the commission that in Ottawa, there were plans being made to clear Ottawa before the invocation of the Emergencies Act. There was all types of issues with the leadership in Ottawa. The chief of police, Chief Slowly, resigned midway through the Ottawa police protests. A new leadership was put in place. We know from the commission that there were plans that were being discussed and made. I think what the problem was, the OPS didn't have enough people to do it. And so you needed all the OPP who were in Windsor to suddenly move over to Ottawa. But the broader question, Poulat, of when do police and when should police interfere in protest is a really, I think, complex question. We have there is a history of other inquiries and other historical facts where, like the Ipperwash inquiry, where we do not want government directing police, right? That is a very important line, because when government directs the police, it is the government taking police authority, the monopoly of violence of the state against people in response to a protest. So the police have to be somewhat independent. They have to be independent of the government. And so when the police are reacting to a protest, they need to be doing it based on their own grounds around public safety, issues around enforcing the law. And it cannot be that the police are seen to be doing the government's bidding in quelling protest. So, this case presented, I think, such a fundamental cognitive dissonance around politically, okay? Because the people who are just generalizing, just really generalizing, the people who are protesting in Ottawa, I think many of them identify themselves as allies of the police and believing that the police do the right thing. Many people who racialized minorities in the country who protest the police actually were wondering why the police was not removing these protesters and was not acting more violently, right? There was this, and some progressive circles were waiting for the police to enforce against the protesters, whereas those progressive circles are often the first to criticize the police, right? You had this weird situation politically. What's really important is that while we do, as the Canadian Civil Liberties Association at the commission, we had to explore this issue of making sure that the government is not directing the police. We do not want that in a democracy, right? And we don't want it to be that invoking the Emergencies Act allows the government to direct the police, because we don't want it to be invoked in response to political criticism of the government.
Fascinating. Let's talk about the decision. So what were the issues before Justice Mosley?
So I'd probably put them in two buckets, okay? The first, let's ignore mootness. ignore mootness. The first issue really was the government justified in invoking the Emergencies Act? That's the administrative law issue. And then the second big bucket is, were the measures that the government implemented, were they constitutional or did they infringe the charter? So those are the two big buckets. On whether the government was allowed to invoke the Emergencies Act, the government had to meet a two-part test, essentially. There had to be a national emergency, and the emergency had to pose a serious threat to the security of Canada within the meaning of the CCLA Act. So on that first point, was it a national emergency? The question was, and we talked about this a bit earlier, are the existing laws of Canada sufficient to deal with the emergency? Are the existing laws sufficient? Does the government have the means to deal with the emergency? And Justice Mosley said, actually the government did. The existing laws of Canada were sufficient. The second part about threat to the security of Canada, this was a super controversial part that came up at the commission, came up at the JR, and the issue was this. The Act says, is there a threat to the security of Canada within the meaning of the CCLA Act? Within the meaning of the CCLA Act. We find out during the commission that the director of CCCLA told Cabinet that he did not believe that the Freedom Convoy constituted a threat to the security of Canada. And so the question became, okay, so you have CCCLA saying this isn't a threat to the security of Canada, but Cabinet saying it is. How can Cabinet come to a different conclusion of the same words and the same definition than CCCLA? And what Justice Mosley says is, well, Cabinet can come to a different conclusion because it can be looking at different facts. It's not bound by what CCCLA says. It doesn't have to defer to CCCLA. But at the same time, it has to explain what that other thing is. Here, the government really relied on the economic repercussions of the protests, the economic repercussions of the closing of the borders. And Justice Mosley says that's not good enough because the Act refers to, we refer to the CCCLA Act. Threats to the security of Canada have to be threats of serious violence. You can't expand that to economic concerns. And he's like, maybe that's a good idea for law reform in the future, but you have to exercise the Act the way it's written today. And the way it's written today, it did not include economic concerns. So the court says the government was wrong. It was not reasonable. It was not reasonable for the government to invoke the Act. That's on the admin stuff. On the charter stuff, there were five rights at issue: freedom of expression, freedom of assembly, freedom of association, right to life, liberty, and security of the person, and right to be free from unreasonable search and seizure. So we won on two of the five.
On two. That's good. Good.
Not bad.
Good percentage.
So.
And you won on section 1 on both.
Won on section 1 on both. So the court found that there were limits placed on freedom of expression because of the limits on freedom of protest. The court found that there was not an infringement of the right to freedom of assembly and freedom of association because the limit that was placed was that you couldn't engage in assembly that could lead to a breach of the peace. No limit on the right to life, security of the person, but there was a limit on the right to be free of search and seizure. And that was really about the economic measures. So what happened was the economic measures said that a financial institution had to freeze the accounts of anyone who was participating in these protests. And we know based on the cross-examination of the RCMP that we did, that what happened in practice was the Ottawa Police Service or the OPP would walk around Ottawa, identify the plates of cars that were parked in Ottawa, provide those license plates to the RCMP. The RCMP would send a list of people to the financial institutions, and the institutions would freeze those bank accounts. And you know what, Pula, maybe you and I, because we're Eastern European, we find that all like super like, whoa, this is bad. So, and the court found that it was bad because there was no standard in the measure as to when the police should be doing that. Like, what is the standard? Reasonable suspicion, reasonable grounds. What was the standard? There was no standard. And that's the admission we got on cross-examination from the RCMP, that there was no standard. And that's just very problematic, because anytime the police is going to take any action against you in terms of search and seizure, there has to be an objective standard by which they have to comport themselves. And the court also found that the financial institutions were acting as agents of the state, which was, you know, maybe apparent, but I think still important. And then, yeah, we went on section 1 that these measures weren't justified.
So tell me something, why was it even an issue that freezing bank accounts is seizure under Section 8 of the Charter?
Because that was a bit controversial, that seizing bank accounts is not an act of search and seizure.
Don't we have case law on that already? Was this the first case ever where they freeze bank accounts and the government says, oh, no, that's not seizure. That's just, you know, that's just the suspension of services or something, right? Or something like that. And I read through that discussion in the decision, and it really struck me how, I don't know whether this was just something that never been considered before, but, and it's also related to this idea of what is money and what are bank accounts, right? And whether the so-called money in our bank accounts is really our money. Because when they said this is not seizure, what they actually said, this is really accounts payable by the bank. It's not your money. And we're not seizing it when we're telling the bank not to pay the bank's debts to you. We're just interfering with contracts. That's all we're doing. I think this is what the government has been saying. And I mean, it's just conjecture, but it sounds to me like that. They are telling us that our money is just IOUs, and the banks can simply stop paying on those IOUs, and it's just a contractual issue, even if the government tells them for whatever reason. And it's not a charter issue, it's not a civil liberties issue, because it's just, you know, it's just an account receivable for you, an account payable for the bank. So, and it's just a contract, so between two private parties. For example, with crypto, it's different with cryptocurrency, because they seize actual USBs, they seize actual hardware wallets, right? And it's hard to argue that it's not seizure, but here they try to pull it off. They try to say, you know, freezing a bank account, suspending your life in modern civilization as you know it, it's not a charter issue. It's just, you know, interference with contract at best. So do you remember that aspect of the argument?
So Ajay, my associate Brandon Chung did all the Section 8 argument, and he did a fabulous job on it.
Yeah, he's a great guy. Yeah, I met him. He's an amazing guy, amazing lawyer. Yeah.
So he did all the argument on it, and he did an amazing job on it. And, you know, I think what the government was trying to say is, by we're not seizing your accounts, we're just holding them. It's just a hold, right? It's just a hold. We're not taking anything. But that was just, you're right. There was no case law directly on point. That's why this part of the decision is a bit longer, and there's reasoning by analogy to other cases and citation of books on this. But I mean, I think it's important to say that just freezing somebody's accounts, even temporarily, I think to most lay people does feel like a seizure, because you do not have access to this now. You're not able to use it, right? Like it's frozen. So I think it's a good, you know, it's probably a significant development in search and seizure law, but that's not my area of expertise, Poulat. Other people will debate whether this is momentous or not.
I think what you did and what Brendan and Matt did, what you three did, and other lawyers, by the way, the Canadian Constitutional Foundation lawyers, what you guys did and other lawyers for the applicants was really momentous and precedent setting. And what does the future hold? What's going on right now?
Well, the government announced its intention to appeal the decision. So that's going to go up to the Federal Court of Appeal. Probably won't be heard until the fall of this year. And, we'll continue to be there for the CCLA to, uphold Justice Mosley's decision, and we'll see what happens. We'll see what happens from there. I assume the government will not argue that it was moot now at the Federal Court of Appeal.
I was wondering, didn't they waive the right to appeal by taking the position that the decision is moot? I mean, of course not, but this is a procedural thing. But it's kind of counterintuitive now to appeal a decision when you first argued that it has no consequence anymore. Yeah, go ahead.
No. So that's all I was going to say, Paula. Yeah, I agree with you. Like, it's obviously it's an important enough decision that the government's appealing it.
Of course, it's a very important precedent-setting decision that will define, I think that will set direction for several areas of the law, both in criminal law and in other areas of the law and administrative law and constitutional law. So what is the timeline? When are you going to get heard? Did they serve you with a notice of appeal? What's going on right now?
So we don't have a notice of appeal yet. The notice of appeal has to be served within 30 days. And then the Federal Court of Appeal rules are pretty fast on the timelines. There has to be an appeal book within, I think, 60 or 90 days. Then the government files their appeal factum, and we have 30 days to respond. And it hopefully will be scheduled to be heard by the end of this year.
And CCLA is happy enough with you, of course, to keep you on for the appeal, I assume.
Yes,
you and the team.
True.
That's great. That's great.
Yes.
That's amazing. I'm very proud to count you as my friend. You make precedent-setting. You cause precedent-setting decisions to be made. I really appreciate your time and this opportunity to meet together and on this very compressed timetable to share this information with our viewers, other lawyers in Canada. Thank you so much, Ewa.
Thank you so much, Pulat. Always a pleasure. And thank you for having this show. I think it's a real good service to lawyers and especially to law students. And thank you for the time that you take in producing it.
Thank you.